Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. On the 1st December 2023, two judges bench, Abhay S. Vokha and Pankaj Mittal, they were literally shocked when an advocate told them that he is not going to argue before a particular bench of the High Court. What? How with so much of audacity, he told that he is not going to argue before a particular bench. So, this has happened while inquiring into the matter of Krishna Kumar versus the state of Uttar Pradesh. Krishna Kumar versus the state of Uttar Pradesh in diary number F18594 by 2023. How this thing can be allowed? Definitely, immediately the Supreme Court took it as a matter of contempt and given notices to the advocate. That is one part. But how he has got that much of dare to say that he will not argue before a particular bench? Where are the professional ethics? What are we doing? We are taking a full semester teaching you the professional ethics, that you must have a respectful attitude toward the court. You must respect the court. Maybe there may be anybody on the bench. We don't bother. But you have to give them respect. You have to argue them. But somehow the advocate is not willing to argue before the particular bench in Uttar Pradesh High Court. The conduct of advocate to argue before the particular bench of the High Court. So the Supreme Court was a shock. Right. Case law I already told you. Right. Here the matter relates to the conviction of that Krishna Kumar and others in a different provisions of the Indian Penal Code, of course murder case, and against the conviction the appellants moved the Allahabad High Court, UP High Court. Therein the court had granted them bail till the disposal of the appeal. Normally you call it a suspension of sentence. Because it's a murder case, they were given bail. They were directed to surrender after a particular period after the disposal of the so-called appeal. Right? But please remember, when the matter was listed for a hearing, when the advocate has to submit his arguments regarding the appeal against the conviction of the appellants, but the advocate, the counsel representing the appellant, refused to argue before the High Court. Reasons actually I do not know, and they were not mentioned also. Reasons may be anything. You should have asked for the transfer of transfer to another bench. How can you say that you don't argue before the particular bench? So maybe there may be strained relations between the bench and this advocate, or the advocate might have been not in good terms with one of the High Court judges. Something might have happened, but actually we do not know the story. As far as we know, what we know is that the advocate refused to argue before the particular bench. So therefore, the matter travelled to the Supreme Court. Right? So against this backdrop, now the matter has come before the Supreme Court, and Supreme Court, see what they have written. We are shocked to note that the advocate appointed by the appellants was bold enough to tell the concerned bench of the High Court that they will not argue the matter. So of course we are separately dealing that again. Now what to do? This is the more important thing. If the advocate doesn't argue, then what the High Court has done is they have cancelled the bail. They have cancelled the bail, and the fellows have to once again surrender to the court. But the procedure, now the Honorable Supreme Court of India discussed the procedure. Suppose if the advocate is not willing, then what the High Court has to do? They have to appoint an amicus curie, because you can't take away the rights of the accused for bail, for appeal. Yes, they have got a right to appeal. So that right can be protected by appointing an amicus curie who will support those persons, or legal aid is already there. So therefore, they should have appointed an amicus curie to assist the court as well as the appellants. But they cannot once again ask them to come back, failure to appear before the court. It's not correct. Needless to add that only on account of default by the advocate, it is not the default of the appellants. It is the default of the advocates. The appellant should not have been penalized. So, and the order is drastic order of cancelling the bail. So with this consideration, Honorable Supreme Court of India restored the bail to them and asked the High Court to appoint an amicus curie so that the matter can be heard in appeal, and of course it may be decided in the way the court likes. So here the important point you have to learn is when the Council of Advocates fail to appear before the court, or when they have got the audacity to say that they don't appear before the court, definitely better to appoint an amicus curie and get the matter continued during the trial. So this is what I want to emphasize on this particular case. Thank you.